Social conservatives also think that none of us can flourish simply with freedom. So one of the ways in which a social conservative will differ from a libertarian, even though both are frequently classified as being on the right or housed on the right, is the idea that none of us is born ready for the responsibilities of liberty.
Ryan Anderson of the Ethics and Public Policy Center talking about his presentation at the 2026 Issues Etc. Making the Case Conference.
So we need families, we need communities, we need churches and synagogues, we need schools and universities to form us. We also need law to form us. Law and culture, they both shape us, they shape our beliefs, they shape our actions. And so if we want to defend freedom, we also need to defend formation. And that means the ability to draw a distinction between liberty and license.
You can hear Ryan Anderson making the case for social conservatism at the Making the Case Conference, June 12th and 13th at Concordia University, Chicago. Register online at issuesetc.org.
The emperor has no clothes on. He's buck naked. That child had to speak the truth no matter how it would make the king feel. And we have to do that today. We have to be very conscientious objectors to the madness that is gender ideology.
And most people default into this idea of feminism is this idea that men are contemptible, which is, of course, the idea behind the smashing the patriarchy, and women need to be just like them and have the same equality.
The Crusades were a very belated response to many centuries of Muslim conquests, in which 2/3 of the old Christian world had already fallen to Muslim conquest.
And our faith is strong, not because of the fervor of its affection, but because of the object to which it clings, Christ. And there is no stronger faith than a really timid grasping to the suffering, death, and resurrection of Jesus.
Families sailing on their family vacation on lakes in Minnesota love Issues Etc.
We love Issues Etc.
So Walter Scott, a Scottish author, penned the famous axiom, "What a tangled web we weave when first we practice to deceive." It's kind of obvious in its meaning that when we practice dishonesty, well, things tend to spin out of control like a tangled web, and we get caught in it. Well, that often happens in ordinary life, and it certainly happens when it is occurring on a corporate scale. Welcome back to Issues Etc. I'm Todd Wilkin. Thanks for tuning us in live on this Tuesday afternoon, the 9th of June. We're going to get an update on the very tangled web that has been woven by the leaders of Concordia University, Texas, and a lawsuit between that university and the Lutheran Church Missouri Synod. Tom Halvorson joins us. He's an attorney in Montana. He's author of a column titled LCMS Persists in Asserting Federal Jurisdiction of Concordia University, Texas Case. Tom, welcome back.
Thanks, Todd.
It has been a long time since we discussed this case, so refresh our memory, and for the benefit of our listeners who might not even know the case, what were the original actions or events that formed the grounds for the lawsuit between Concordia University, Texas, and the Lutheran Church Missouri Synod?
Well, the context was that the Missouri Synod had established universities as agencies of the church, including Concordia University in Austin, Texas. And the church had owned property there since 1925. The university charter stated that its affairs would be controlled by, originally it was a board of trustees, later a board of regents, elected in accordance with the synod's bylaws, and that they would be subject to the control of the synod, especially with regard to its doctrine and religious practices. But then suddenly and unilaterally, all by itself, and not with any agreement with the synod, in November of 2022, a majority of the regents, and we should emphasize it wasn't all of them, there were some that were innocent, but a majority of the regents voted to unilaterally rewrite its internal governing documents, which would mean its articles of incorporation, bylaws, and policy manuals. And they made dozens of changes. I'll just give you a handful of the key ones. The changes denied that the university, its regents or officers, owed any duty of stewardship to the Synod at all in any respect. The changes denied that the university was subject to any authority or governance by the Synod. It rejected the right of the Synod, according to the Synod's bylaws, to elect regents to the Board of Regents of the university. It rejected the right of the Synod to appoint some other seats on the Board of Regents through officers and other bodies of the Synod. And it made itself, or declared itself to be, self-perpetuating, meaning when you have a vacancy or somebody's term runs out on the Board of Regents, the regents themselves, rather than the Synod or its convention or its officers, would fill that vacancy and appoint all of its own members. And a key thing is that it rejected any authority of the Synod over what doctrine would be taught to the students at the university. And the last kind of main one is that, in effect, this took absolute control of the property of the university. That would be the grounds of the campus, the buildings, and all the rest of the property, and rejected any right that had previously existed of the Synod to a reversion in case the school would stop being used as a synodical school. So in our theology, under the fourth commandment, where the authority of parent, mother and father over children, is sort of the archetype or the cookie cutter from which all other human authorities are cut, you have a parent authority, the Synod, and you have a child authority, the university, and now the child is essentially rebelling. So it was a rebellion against the fourth commandment. And then under the 7th, 9th, and 10th commandments, it was theft of the Synod's property. So those were the original actions or events that set off a series of further events that led to the lawsuit.
So how did the Lutheran Church of Missouri Synod, and we should say here, through its properly designated fiduciary responsible body, that is the Synodical Board of Directors, how did the Lutheran Church of Missouri Synod respond to those changes?
It's good that you mentioned about the correct entities. In 1847, the Synod was created, and then in 1898, they completed study that they had been doing since they were formed in 1847 about how to live under the Lutheran doctrine of two kingdoms in the setting here in America, after they'd been here for a while. And they ended up deciding what they needed to do was keep the Synod as it was, as a spiritual body that governed doctrine and religious practices, the mode of worship, hymns, that kind of thing, and rostering pastors, and separate from that the civil business like ownership of property and bank accounts and employment and stuff like that. And to do that, they made a decision that they wanted to be a corporation, and they made a decision that they wanted to be a Missouri corporation. And those are both significant decisions. And they're religious decisions because they're decisions that were made to carry out the Lutheran doctrine of the two kingdoms. So under that, then when the regents took the action they did in Texas, the part of our church, our whole church that we think of, that responded was the corporate synod, which is as it should be because you were dealing with property and articles of incorporation and a key one, lawsuits. Under our doctrine, that the church shouldn't be subject to being sued or be capable of suing. But yet, if there's an interest of ours, of course, we can't be like the only big people with a King's Act that are immune from the society we live in. We are part of the civil society. So we answer those things through the corporation. The corporation could sue if it needed to or be sued and represent the interests of the Synod, but the Synod itself cannot sue or be sued. And in over 100 years, I think it's 136 years, it never has been sued until now. So in carrying that out, then, that means that the decision falls to, firstly, the Commission on Constitutional Matters. That's an internal judiciary, so to speak, and the question was put to them, were these changes by the regents of the university in Texas proper and valid under our rules of our Synod? And they made a ruling that they were not and could not be put into practice. But that's a provisional decision because there's still a higher authority, which is the Synod in Convention. So the Synod in Convention considered a resolution that was prepared for it to discuss, published in the workbook, and widely discussed, to decide whether to affirm what the Commission on Constitutional Matters had decided and what else to do about this. The convention met in August of 2023, and it affirmed what the Commission on Constitutional Matters had said. It confirmed that there was a Fourth Commandment violation concerning the authority of the Synod as a parent organization. And it confirmed the 7th, 9th, and 10th Commandment concern. Went on to call upon the President, Chairman, and Board of Regents of the University to repent, and directed the President of Synod and others to stand ready to grant forgiveness and pronounce absolution if they would repent. That didn't happen, and so what I mean by that is there was no repentance. And so that meant that there was nowhere else to go inside of the organization of the Lutheran Church Missouri Synod. All the internal things, the CCM, the Synod and Convention, everything was exhausted, and there was nowhere to go but to the courts. And the proper authority for that, under this arrangement of the two kingdoms, is the corporation, which is governed by its board of directors. So the board of directors of LCMS Incorporated is the authority, and it was the proper authority under our theology and under the laws of the United States to bring the action that it did in federal court in Texas.
What were the specifics of the lawsuit that was filed by the board of directors for the Lutheran Church Missouri Synod?
Well, the first thing they want is something called declaratory judgment. A declaratory judgment doesn't do anything really but say how things are. And it doesn't make it happen, but it tells you what's supposed to happen. And so the first thing would be to say, hold it, the bylaws of the Synod are still your deal. And under that deal, your articles of incorporation rightly said that you were subject to the control of the Synod, both as to its property, as to how a president is chosen, as to how regents are elected and appointed, who can be a theology professor at the university, all this kind of stuff that the Synod had control of, and the ownership of the property. So the declaratory judgment would say that's still in force, and these things that you did unilaterally are just a nullity. They're just nothing. You think you wrote stuff down on paper, but it's not worth the paper it's printed on. And we're declaring that all of that is invalid, and the deal you originally had with the Synod, that is still in force because you didn't have any authority to just run off by yourself, and you neglected the authority of the Commission on Constitutional Matters, and you neglected the authority of the Synod and Convention. So that's the declaratory judgment. Now, on putting teeth to that, there are some other claims. Breach of contract is a key one, in which it is said that by the articles and so on, a contract was made with the Synod to remain under the Synod's control as to all these things we've been talking about, and to honor the property rights of the Synod. And you breached that contract. So now we want to figure out what are the damages of that breach, and we want you to pay these damages, which could be considerable because you're talking about a $68 million campus. So I don't know how you would figure out the damage for that, and that's going to be something that people are going to have to work on later, but that's what that part of the claim is about. So you have basically two kinds of claims. One is just to declare, to put that this is how things are. And then if that doesn't solve it, then carry on with the contract claims where, okay, if you're not going to honor the declaratory judgment, then you're going to face damages on the contract claims.
So just to summarize this so far, essentially the University of Texas, through its president and some of its regents, a majority of its regents, decided in my term to simply go rogue and reject any and all authority that the Lutheran Church Missouri Synod had over it, according to the bylaws of Synod and those contractual elements. When called to repent by the Synod itself in convention, they did not, and they rejected the regents that the convention had elected for them. I believe subsequent to this, and it may not be material to the lawsuit, they decided to elect a president there outside the ordinary course of things in the Lutheran Church Missouri Synod. The board of directors, on behalf of Synod, then sued the University of Texas and several individuals. Who would that be, Tom?
Well, it would be firstly the president, Don Christian, because of his public statements show that he was in support of doing this and a promoter of doing it, which makes him responsible for it. The chairman of the Board of Regents, Christopher Bannwolf, is specifically named for similar reasons, although he said less publicly, but enough they feel that they have enough evidence that he was part of it. The vote was done in executive session, meaning that we haven't seen the minutes. They're not letting us look at the minutes. That's part of what they're not doing that they should do. They should let us see their minutes. So that's why we don't know exactly who voted. We know it's a majority, but we also know that there were some who voted no that we consider to be innocent regents. And so after that, then they appoint regents who are going on with past rogue to impostor. Rogue is when you're rightly put into an office, but once you're there, you go off the farm and do stuff you shouldn't be doing. That's rogue. But then there's a different category of impostor. When the Synod Convention in 2023 elected 4 regents that the university refused to seat, and instead they seated others, those others aren't really regents. They're just pretending to be regents. They're imposters or posers. So you have rogue and you have imposter. And the question you asked about subsequent, such as Dr. Christy Kirk, who was made into the supposed president by this rogue, partly rogue and partly imposter board of regents, yes, that will become significant. It hadn't happened yet when the suit was filed, so it wasn't mentioned, but it will end up being involved in the suit because she similarly will have a part in perpetuating the wrongs that are being committed against the Synod. So there's a bunch of what they call them John Does. There's Doe 1, 2, 3. I think there's either 10 or 12 of them. And that's what you do when you file a lawsuit, and you know there's some more responsible people, but you haven't discovered who they are yet, and you will probably discover them during the suit, and you then later name them. So there are these 10 or 12 John Does that are listed as defendants. I wouldn't be surprised by what Christy Kirk will become one of them. These 4 imposter regents will likely become some of them. Or some of the ones that will end up in those slots will be the majority regents. We just don't know which ones they are yet. Once we get the minutes in discovery, that's what those slots are used for. And they might end up having to add and end up with maybe as many as 15 John Does before we're done.
Tom Halvorson is our guest. He's giving us an update on a lawsuit between Concordia University, Texas, and the Lutheran Church Missouri Synod. When we come back, we'll talk about the architect of this alleged theft of a university.
This week on The Word of the Lord Endures Forever, we continue working through Psalm 119 with a wide place, comfort in my affliction. The earth is full of your steadfast love. It is good for me that I was afflicted, and your hands have made me. Join me, Pastor Will Whedon, for The Word of the Lord Endures Forever, your daily 15-minute verse-by-verse Bible study on demand. Listen at thewordendures.org or your favorite podcast provider.
What did Martin Luther mean when he wrote that Christians live in Christ through faith and in the neighbor through love? And what's the difference between self-improvement and self-transcendence? Find out in the Issues Etc. Book of the Month for June, Lift Your Eyes, How to Live Outside Yourself. Learn more and purchase Lift Your Eyes at issuesetc.org or by calling Concordia Publishing House 1-800-325-3040. Lift Your Eyes, How to Live Outside Yourself, the Issues Etc. Book of the Month for June.
Lutherans for Life assists for-life Christians in offering the hope and help of the good news of Jesus Christ to women with an untimely pregnancy, women, men, and families suffering under the guilt of an abortion, young people with questions and concerns about sexuality, and the elderly and those with disabilities or terminal illnesses. Learn more about LFL resources and forming a life team or life chapter, or becoming a life advocate by calling 888-364-LIFE. That is 888-364-5433, or by visiting lutheransforlife.org.
Teaching the great books helps grow students' love for what is good, true, and beautiful. That's why Memoria Press publishes literature guides for students in 1st through 12th grades. These user-friendly guides teach students to contemplate classic novels so that they may grow in wisdom. Learn more at memoriapress.com. Save $5 when you enter the coupon code LPR26MP. Memoria Press, saving Western civilization one student at a time.
Educating a new generation of Lutherans. You're listening to Issues, Etc.
Thanks to the following congregations for standing with us by becoming an Issues, Etc. congregational sponsor: Trinity Lutheran, Louisville, Minnesota; St. John Lutheran, Napoleon, Ohio; Good Shepherd Lutheran, Bloomington, Illinois; Grace Lutheran, San Mateo, California; Emmanuel Lutheran, Frankentrost, Michigan; Our Redeemer Lutheran, Dubuque, Iowa; Calvary Lutheran, Mechanicsburg, Pennsylvania; St. Paul Lutheran, Wellston, Oklahoma; Zion Lutheran, St. Charles, Missouri; Shepherd of the Valley Lutheran, Perrysburg, Ohio; and Redeemer Lutheran, Fairhope, Alabama. Find out how your confessional Lutheran church can support this worldwide outreach by including Issues, Etc. in your mission or advertising budget. Just go to issuesetc.org, click Support Donate, and print a one-page flyer. When your congregation becomes an Issues, Etc. sponsor, we'll publicize your church on the podcast, at our website, and in the Issues, Etc. journal. Welcome back. I'm Todd Wilkin. We're getting an update on a lawsuit between Concordia University, Texas, and the Lutheran Church Missouri Synod. Tom Halvorson is our guest. Tom, you had mentioned Dr. Christy Kirk, the current president of Concordia University, Texas. It was through her doctoral dissertation, I believe, that she, at least in my opinion, kind of came forward as the architect of this action by the leadership of Concordia University, Texas.
Well, something like 21 or 22 years before all this happened, she got her doctorate degree, and in her dissertation, her subject was new forms of relationships for the governance of universities in Lutheran schools. Now, she wasn't just talking about the Missouri Synod, but at the time she was provost of Concordia, Texas, which is a Missouri Synod school. But she was writing more generally. And so she was talking about how this has traditionally been done and, how times have changed and how it needs to be done in the future. And basically, it was a theory of academic independence and, the university gone wild versus being an agent of a denomination. Like it could be, the ELS or Wells, and it wouldn't even have to be Lutheran. It could be the Southern Methodist. It could be the Southern Baptist Convention. It's this theory of independence of the academy. And so having written that out, then she talked about how do you get there. That's what that dissertation was. And so I don't want to ascribe motives or design or something like that, but I will say this. If you read the dissertation and then you look at the events, you would have a hard time slipping a cigarette paper or anything that thin in between the design of the dissertation and the events that actually happen. They correspond very neatly. So whether you want to call that architecture or what you want to call it, I don't know, but that correspondence does exist.
Many have speculated, I among them, that one of the reasons that Concordia University, Texas attempted to reject the governance and oversight of the Lutheran Church Missouri Synod was they were intent upon hiring a female president, which would not have been approved either in the bylaws of the Lutheran Church Missouri Synod by the LCMS or by President Matt Harrison, who has a significant hand ordinarily in the election of a president. I speculated at the time that was part of the goal here. I believe I was proven true when she was named president, but what are your thoughts there, Tom?
Well, again, I don't know about the intent aforehand, or the motives, but I will say this. In the bylaws of the Synod, and then in the documents at the university that are in conformity or used to be in conformity to the documents of Synod, the office of president is declared to be not only a name, but with some specificity and some details, the spiritual leader of all the students on the campus. So it isn't just we're running some secular thing. We have a university just like the University of North Dakota or the University of Montana. No, we're running a religious school for religious formation so that Lutherans, under the Lutheran doctrine of vocation, could understand how to be Christians in their vocation, serving the Lord and their neighbor according to our religion. And the leader of that formation spiritually is the president. Now, there are some others too that share that responsibility with the president, but the president has that. Once you know how religious the position of the president of the university is, then I think it'd be a lot easier for people who, wonder sometimes about restriction of women's roles in the church. I think that it would be easier for them to support the idea that that should be a male-only position, similar to our pastors and so on. And so, yeah, I don't think that had the bylaws been followed to fill a vacancy when Don Christian retired, there would have been a snowball's chance that any woman, it isn't because of Christy Kirk, but anyone, because that spiritual leadership for our children in a university, that's a male role. But now, as far as the intent and design, you're right. There's a correspondence, a neat fit. I mean, that what you're saying isn't 20/20 hindsight. You said it beforehand. You said it quite a ways beforehand, and now it has happened. And I don't know of any other path that it could have happened besides this whole scheme that fits along with her dissertation that ended up being played out by the majority of the regents when they made these changes to the university's bylaws. So, I mean, you could be forgiven. I think a lot of people in the Synod or other onlookers could be forgiven for taking the interpretation that you have.
So let's talk about the issue of jurisdiction. How was that raised in the course of this lawsuit? And tell our listeners what has happened in federal district court over the jurisdiction issue.
Yeah, that's where things get maybe a little bit down in the weeds. We've talked about this with your listeners before, and I'll try to keep it simpler and probably a little more brief than in the past, since we have been over it some, and there you have an archive for your people that you love, your on-demand listeners. But if you file a lawsuit in state court, there's an assumption that the court has jurisdiction over almost any kind of a subject matter you could file. It's called a court of general jurisdiction, and general means they take everything from soup to nuts. And so when you file a lawsuit in state court, you don't start off by saying why you're there and why the court has jurisdiction, because it's presumed that it has jurisdiction. Federal courts are just the opposite. They are courts of limited jurisdiction. There's no presumption that they have jurisdiction because they usually don't. It's an exception when they do. For example, one of them is a suit between two states. If North Dakota and Minnesota get into a lawsuit about coal, which has happened, well, that's between two states of the union, and you can't go to Minnesota and expect them to be fair to the North Dakotans. So that's going to be federal. In a private deal like this, where there isn't a government entity involved, and their claims could look like, well, it's contracts and corporations and property and stuff, ordinary business, you could say, well, that belongs in state court. But Congress saw that if all of the plaintiffs were of one state and all of the defendants were another, and the suit was filed in either set of state courts, that there could be bias or favoritism of, say, a Texas court for its Texas citizens. And that would be especially true if those judges are elected and not appointed because they want to be reelected. And so they said, this will be one of our exceptions. We're going to let cases that ordinarily should be state law cases, we're going to let them be in federal court when there's an absolute or complete diversity of citizenship between the parties. The LCMS Inc. is a Missouri corporation, and CTX is a Texas corporation. Dr. Christian and Dr. Bannwolf are citizens of Texas. So everybody on the defense were Texans, and everybody on the plaintiff was a Missourian. So that was an absolute diversity of citizenship, and that is why the board of directors of the LCMS filed in federal court to get away from any bias of a Texas state court. And then what CTX did, you got to give them credit for creativity here. They invented a new and novel idea that the Synod is an unincorporated association under Texas law. It isn't just the Missouri Corporation, and it isn't just the ecclesiastical synod that has no capacity to sue or be sued, where only the Missouri Corporation can be sued to represent the interests of the ecclesiastical synod. And because it's an unincorporated association, and membership in that association includes rostered Missouri pastors in Texas and member congregations in Texas, that means that this unincorporated association is a synod of many states wherever there are churches and pastors, including Texas. So now you don't have a diversity of citizenship, because now you've got people that are on Missouri on both sides and Texas on both sides. And that's how they wanted to bump this out of federal court and run it back to state court. They actually filed a simultaneous lawsuit over in state court while they were doing that. So the question then becomes, who is the synod? I mean, who's the proper party to the case? And a lot of time has gone to this, a lot of briefs, a lot of discovery, affidavits and whatnot. We have had arguments in front of the district judge. There was a magistrate judge appointed by the federal district judge to make a study of this and give a report and recommendation. The magistrate judge basically swallowed the CTX argument hook, line, and sinker. And then the district court judge pretty much tracked with what the magistrate judge said. You know, the magistrate judge, I don't know anything about him. I didn't find a lot of information about him. The federal district judge has got a well-known, really solid reputation as a good judge. But on this one, he was slipping a cog when he did this one.
Tom Halvorson is our guest. We're getting an update on a lawsuit between Concordia University, Texas, and the Lutheran Church Missouri Synod. We'll talk more about Concordia University, Texas's attempt to redefine synod next.
This is Molly Hemingway of The Federalist, inviting you to join me for the 2026 Issues, Etc. Making the Case Conference, Friday, June 12th and Saturday, June 13th at Concordia University, Chicago. I'll be speaking and signing copies of my new book, Alito, the Justice Who Reshaped the Supreme Court and Restored the U.S. Constitution. Learn more at issuesetc.org. issuesetc.org.
For nearly 140 years, the Lutheran Witness has taught the faith, defended it against error, and shown forth the great treasures of the Lutheran Church and biblical doctrine. We're continuing this legacy by publishing issues and articles that help you see the world from a Lutheran perspective and that teach biblical doctrine and show forth the treasures of God's Word. Visit our website to learn more and how to subscribe, witness.lcms.org. The Lutheran Witness, helping you interpret the world from a Lutheran perspective.
Here's an easy way for you to help us contend for truth in an age of anti-truth. Subscribe to the Issues Etc. podcast with YouTube, Spotify, and Apple. Just type Issues Etc. in the YouTube search engine and click subscribe. For Apple and Spotify, type Issues Etc. in the search engine, hit follow, and leave us a 5-star review. Help us inform other podcast listeners by subscribing to the Issues Etc. podcast with YouTube, Spotify, and Apple.
Confessional Lutherans, we've got your back. You're listening to Issues Etc.
If you're visiting Frankenmuth, Michigan, come to Emmanuel Lutheran Church in nearby Frankentrost. A hardy band of German missionaries founded Emmanuel Frankentrost in the wilderness near Saginaw. At Emmanuel, you can still hear the law and gospel in a beautiful liturgical service, just like those first settlers. For directions and divine service times, visit frankentrost.org. That's FRANKENTROST.org.
Your church service, sanctuary, and congregation are all unique, so why settle for low-quality recordings when your organist is unavailable? The Substitute Organist service from Church Music Solutions is genuine organ leadership using your instrument with your specific selections when you need it. Log on to churchmusicsolutions.com and request a free demo kit to allow you and your members to use the Substitute Organist service without obligation and without a sales pitch. Keep singing with Church Music Solutions.
We are getting an update on a lawsuit between Concordia University, Texas and the Lutheran Church Missouri Synod. Tom Halvorson is our guest, author of a column titled LCMS Persists in Asserting Federal Jurisdiction of Concordia University, Texas case. Dr. Ryan Anderson, president of the Ethics and Public Policy Center and member of President Trump's Religious Liberty Commission, has been added to the speaking lineup for this week's Issues, Etc. Making the Case conference. Dr. Anderson will be making the case for social conservatism. The premier conference for Christian laity is this Friday, June 12th and Saturday, June 13th at Concordia University, Chicago. There's still time for you to register and to book an on-campus dorm room. Register online at issuesetc.org or by giving us a call, 618-223-8385. The 2026 Making the Case Conference, June 12th and 13th in River Forest, Illinois. Tom, I want to come back to something you mentioned before the break. Just tell me if I'm right here. It sounds like Concordia University, Texas, through its attorneys, was not only making up a completely novel legal concept, but they were also attempting to redefine synod, contrary to how synod defines itself in its constitution and bylaws as a church body.
You just put your finger on it, and this is, I'm an attorney. I've been an attorney since 1978, and a lot of times I'm not too happy with how things are going in the legal system. I'm going to turn 73 next month. I talk to my good friends in the practice, and we talk about what we're not going to miss because of our disappointments in how the legal system goes. But by golly, when this opinion came out from the Fifth Circuit, Todd, I am telling you, this is one of the most exquisitely satisfying things I have read in a court opinion in 5 or 10 years. The majority of the Fifth Circuit said what you just said. Of course, they spoke of it in jurisprudential manner, but what you just said is exactly the key thing. There are two opinions, and so I'm going to break this down in two parts, one opinion and then another. There's a majority opinion. The panel had 3. 2 people voted for the majority opinion. That's why it's called that, because a majority of votes. And then there was a concurring opinion, and I'll explain that one in a minute. But in the majority opinion, here's what they said. What you just said, Todd, it was a religious decision. These people are Lutherans, and they have had, since the Reformation, the doctrine of the two kingdoms. And for that matter, since the Reformation only reformed the church and didn't invent anything new, really this doctrine was 2,000 years old. And the Lutherans are simply trying to follow it. And when they had gotten to America in 1848, they needed to spend some time thinking about, now that we're not in Germany or in Norway or someplace, we're in the United States, how are we going to carry out our belief in the two kingdoms here in the United States? And by 1898, they had made their decision. And it was a slow deliberation. They really thought this through. We're going to have a synod that cannot sue or be sued, because that's the kingdom that shouldn't have any business with the civil realm on that. But we do have to answer to the civil realm or participate on our own rights in the civil realm. To do that, we will make a Missouri corporation. We want it to be a corporation. We want it to be a Missouri corporation. And that's who's going to respond in the civil realm. The chief judge, writing for the majority, said, that's pure religion. That's them working out. In other words, when they say two kingdoms, they're not just preaching to the world that everybody else should think about two kingdoms. They preach to themselves. They said, we have to follow our doctrine. We say that it's two kingdoms established by Christ. And so now that's how we're going to live. And this is how we're going to do it. We're going to have a synod that's ecclesial. We're going to have a corporation that is civil. Therefore, for the district court to have inquired in and start raking through the bylaws of the synod and raking through its constitution, raking through its policy manual, and picking up one little paragraph out of a 4-inch ring binder of policy and bringing that out like it's the be-all and end-all and the total story to declare, yep, you are an unincorporated association under Texas law. You don't even have to look at corporation law. You don't even have to look at Texas unincorporated association law. You just have to look at the fact that the district judge was meddling into religion. And that is a violation of the church autonomy doctrine, which grows out of the First Amendment in the United States. And the court used some tough language. She said that it was a quintessential violation, quintus, fifth, and essence. Quintessence is the fifth element, or in other words, something so purified you couldn't get a better example of it. I mean, if you were going to have a dictionary where you put violation of the church autonomy doctrine on the First Amendment as an entry, the picture next to it would be the district judge in this case who fooled around with trying to tell the Synod what its documents meant. And the Fifth Circuit said, wait a minute, hold it. The church is in charge of what its documents mean. That's what the First Amendment tells us. Now, the concurring opinion, as bad as everything I just said already was, the concurring opinion is actually worse for the judge and for CTX, because she says, I concur in the majority opinion, and all of that is true. It's a violation of the liberties under the First Amendment. But, we never really needed to even get into that, because if you just take it as a matter of corporation law, and you read articles of incorporation, you read bylaws, and you don't cherry pick, this is a key phrase that she used, you don't cherry pick one thing and amputate it out of the body, and now you have a dead organ over here separated from the body, and you're trying to say what that means or what its function is without keeping it in the body. You read all these documents together and you harmonize them so that they speak with one voice and are consolidated. If all you did was that, ordinary corporation law, you would have seen that this is a Missouri corporation. It is not an unincorporated association. And the corporation in Missouri was designed to be able to handle and respond to these litigation situations, and that is what they're doing. They're being a responsible citizen of the civil kingdom by having a corporation. And that's all we had to do. We didn't even have to get in to the First Amendment. I agree with what the majority said about the First Amendment, but we never even needed to do it because it was way simpler than that. So I have to wonder, sitting over there in Austin, what the attorneys and the judge and everyone are doing reading this. They need to think about, this was a jurisdictional decision, so it is not a decision on the merits, but there's a lot between the lines there about where this may be going on the merits that they need to stop and think about.
Tom Halvorson is our guest. We will get into what happens next in this lawsuit between Concordia University, Texas, and the Lutheran Church Missouri Synod. Stay tuned. What can we learn about the worship practices of the first Lutherans from a Reformation edict by a Calvinist leader? Find out in Will Whedon's column in the latest Issues Etc. journal. We'll send it to you for free. Just click the red journal subscription button at issuesetc.org and enter your email address. In the Wittenberg Trail feature, Pastor Michael Hughes writes about his journey from progressive Lutheranism to confessional Lutheranism. The Issues Etc. journal. Subscribe for free at issuesetc.org.
Luther Academy provides additional theological education for our mission partners around the world, specifically pastors who are asking for additional education but do not have the necessary resources in their own church bodies. By donating to Luther Academy today, you will be supplying food, housing, books, professors, and travel for Lutheran pastors who attend our conferences. To learn more about Luther Academy and how you can donate today, visit lutheracademy.com. lutheracademy.com.
Continuing education for the confessional Lutheran. You're listening to Issues Etc.
Are you looking for a confirmation gift for the confirmand in your life? Ad Crucem has a huge selection of lovely gifts to suit any budget. See our jewellery or browse our prayer aids with stunning icons, plaques, crucifixes and certificates. Our personalised ornaments and boxes are other great ideas. And of course, our theologically sound greeting cards complement the gift perfectly. Visit adcrucem.com. That's ADCRUCEM.com.
If you continue in my word, you are truly my disciples, and you will know the truth, and the truth will make you free.
Dr. Russell Dawn, president of Concordia University, Chicago.
Indeed, the quest for truth is at the core of a university's purpose. The liberal arts, illuminated by the revealed truths of Scripture, are powerful for equipping students for a life of self-governance. A disciple is one who follows the Master. So what does it mean to follow Jesus? He said that it means to take up one's cross. The cross is thus the symbol of dying for others, of dying to self for the sake of serving others. And a life of service is a life well lived.
Truth, freedom, vocation. Concordia University, Chicago. cuchicago.edu.
Tom Halvorson is giving us an update on a lawsuit between Concordia University, Texas, and the Lutheran Church of Missouri Synod. I'm Todd Wilkin. This is Issues, Etc. Tom, what happens next? Where does this case go from here?
So they could attempt to, people use the word appeal, but I don't think there is any appeal for this to the U.S. Supreme Court. An appeal means by right, the court has to hear it. There is no right for CTX or Christian or Bannwolf to have this court heard by the U.S. Supreme Court. And probably only about 6% of all the cases that get to the Supreme Court are actually appeals. The way most of them get there is called a writ of review in English or a writ of certiorari in Latin, which is a prerogative writ. It means even if you have all the elements necessary to apply for this writ and you have a good application, it's still discretionary with the upper court whether they want to grant the writ and review the case. So that's why it's called prerogative. A case like this, I don't think is going to get a writ of certiorari granted unless the Supreme Court looked around at the circuits. And this is in the Fifth Circuit. If they looked around and saw that in the Sixth, the Second, the Ninth, and so on, there was a conflict of decisions by the circuit courts over something like this, they might grant certiorari to resolve that conflict. But I don't think that conflict is out there. So I think the chances of this going to the Supreme Court on the jurisdictional question are slim. It could happen, but I think it's slim. So if it doesn't go there, then it goes back to the state federal district court that muffed it up in the beginning and to proceed toward the merits. So the parties continue with discovery where they're doing depositions, they're asking for production of documents and so forth, and then getting the case ready to be tried if it doesn't get settled. It's not going back over to state court. That state court case, I think, is dead because of this ruling. So that's where I think it's going. There's a slim chance it could go to the U.S. Supreme Court on jurisdiction, but I think that's very slim, and my guess is it's going to stay in federal district court now until we get either a settlement or a ruling on the merit.
So I wanted to ask about that because very often I'm given to believe that when these kind of things come before a court, the court will first suggest meeting for a settlement. What would that have to look like to satisfy the legal grievances of the board of directors of the Lutheran Church Missouri Synod?
Well, legally, we would be talking about procedural stuff under the federal rules of civil procedure, where, yes, there is a power of a federal district judge to order a settlement conference in front of a magistrate. I've been involved in those. In fact, I was in a diversity of citizenship suit in federal district court in Montana where the judge ordered us to appear in front of a settlement magistrate. We filed these settlement brochures. They're not exactly briefs, but they're a little bit different genre of literature, but they're kind of like briefs. And then you show up and you talk about settlement in person in front of this magistrate. And in my case, that resulted in settlement. So it can be a very good procedure. And I do think that judges like that. Of course, the whole ethos of the courts is we do try to drive parties to settlement if we can. And as far as the board of directors of LCMS Inc.'s attitude, everything I've seen them do shows that these are good Christian Lutheran guys, and they want to follow Christ's commandments. And if there's a chance to settle, I think they're going to try to take it. They've done a lot of things to try to never have this lawsuit in the first place. And since the lawsuit has started, they have continued to take that tack. And so I just almost wonder if they wouldn't welcome. I can't speak for them, of course, and I haven't talked to any of them about this. But I would be surprised if a settlement order was being thought of by the district judge. I'd be surprised if the Synod wasn't happy to participate in that.
So you have said here already today that Concordia University, Texas, through its various entities, the then president and the majority of the regents and its chairperson have broken several commandments. What are they and why?
Well, you start with the fourth commandment. In Lutheran theology, the fourth commandment, the authority of parents, mother and father, over children, is the basic form of human authority. All other authority is divine authority, God's authority. But then human authority has its picture in mom and dad and their authority over their children. All other authorities, let's say the teacher in the classroom, or a police officer at the intersection where an accident happened and he's investigating and keeping two guys from fighting, or any other human authority, they're all modeled on the authority of mother and father. Now, in the case of Concordia University, Texas, it didn't create itself. It's a child. It was created by the Synod, starting in, what was it, 1925 or somewhere back there. And so, theologically, we have a parent organization, which is the Synod, and then you have a child organization, which is Concordia University, Texas, and all the people that work in it, such as the regents, the president, the provost, and so on, the professors, they're all part of a child organization subject to the supervision on the model of parents from the Synod. When they just rebelled, and literally the rebellion is literally what they literally, it isn't just that they didn't follow a commandment. It's that they talked about the authority itself per se and said it didn't exist and threw it off. I mean, there's no pure reform. Again, it is quintessential. It's a quintessential rebellion saying, you don't have anything to say about any of this because you just aren't part of this anymore. It's like children just waving off their mother and father and saying, you're not my parents anymore. So that's the fourth commandment, rebellion. Now, the seventh, the ninth, and the 10th are about property. The majority opinion of the Fifth Circuit did a beautiful job here again on recognizing that from the beginning, all the documents of the Synod and the university were in agreement that should the university cease to exist, or if it should ever stop being an educational institution serving the Synod under the Synod's control, that then there would have to be a dissolution of the assets and a winding up of the business and a distribution of the assets to the Synod. That's not quite the same thing as a reversionary interest in a deed, but it's another avenue of the same thing happening, so I'll just call it the reversionary interest, even though technically that's the wrong name for it. But there's a reversionary interest. When they took these actions in November 2022, they seized the absolute control of the grounds of the campus. They seized the absolute control of the buildings, the equipment, everything else, the trucks, the pickups, the commissary, whatever they got. And that is a violation of the property rights of the Synod under the Seventh Amendment. And, of course, before theft, you have coveting. I mean, that's why thefts happen, is first there's theft in the heart, which is the 9th and 10th commandments. And then when the hands and feet get involved, now you have the 7th commandment. And Luther, in his large catechism under the 7th commandment, has a lot to say about how people kind of make it look good with secular paperwork. I think he called them swivel chair robbers or something like that, that they sit in high seats. They have swivel chairs. They're in offices, and they pretty this stuff up. It looks pretty professional. It sounds kind of plausible. They've got stuff filed with the Secretary of State, but it's a theft. That's what we say because of our understanding of the seventh commandment as Luther explains it in the Large Catechism.
Tom Halvorson is an attorney in Montana. He's author of a column titled LCMS Persists in Asserting Federal Jurisdiction of Concordia University, Texas case. You can read it on the podcast page for this episode at issuesetc.org. Tom, thank you very much for helping us understand this complex, but I would say morally rather clear issue.
It is morally clear, and in the end, the Fifth Circuit told us that it was legally very clear and simple, too. That's what's so wonderful. It's a clear, easy-to-understand outcome so far.
Thursday on Issues, Etc., we'll discuss media coverage of the faith of U.S. Senate candidate James Tallarico with Terry Mattingly, and we'll talk with Dr. Jordan Cooper about purgatory. We'll also respond to your email, talkback@issuesetc.org, and the Issues Etc. comment line, 618-223-8385. I'm Todd Wilkin. Thanks for listening.
Listen weekday afternoons to Pastor Todd Wilkin and guests on Issues Etc. Issues Etc. is a listener-supported program. Your financial support is vital for the continuation and expansion of this worldwide outreach. Our mailing address, Issues Etc., P.O. Box 83, Collinsville, Illinois, 62234. Box 83, Collinsville, Illinois, 62234. You can also donate at our website, issuesetc.org. Issues Etc. is a production of LPR, Lutheran Public Radio.
Hi, this is Pastor Clayton from Zion Lutheran Church of Muscuda, Illinois, a proud supporter of Issues Etc. Zion is a congregation firmly grounded in God's grace given in the Word and Sacraments, where we treasure the timeless beauty of the liturgy. Zion is also a vibrant, young, family-friendly congregation where you would be warmly welcomed. Zion is located at 101 South Railway Street in Muscuda, Illinois, and we would love to share God's gifts of grace with you. For more information, please visit our website at zionmuscuda.com.
Oh Lord, open my lips.
Listen to chapel services live, weekday mornings from Concordia Theological Seminary in Fort Wayne, Indiana. Morning Chapel from Kramer Chapel. Live, weekday mornings at 9 Central, 10 Eastern, 8 Mountain, and 7 Pacific at issuesetc.org.
This is Jeff Schwartz, General Manager of Lutheran Public Radio, with a message for listeners in the Mountain and Pacific time zones. We pledge to have Issues Etc. podcasts posted daily, no later than 5 p.m. Mountain, 4 p.m. Pacific. This will allow you to download and listen to the latest Issues Etc. podcasts weekdays during your evening commute. Again, if you live in the Mountain or Pacific time zone, download Issues Etc. before you leave work and listen during your drive home.